Assalamualaikum and a very good morning to all of the guests here today. Thank you very much spending your time with us this morning. Okay, I am Khalida, by the way, your host for today. Today's session will be divided into two sessions. The first one is from Puan Haja Aslina binti Ismail, the Senior Manager of Membership and Membership and Membership and Strategic Communication (MEF) uh, to introduce to all of you what is MEF is, overview of our activities, and also what MEF is all about lah. Okay, without further ado, I nampak Puan Haslina pun dah ready. Saya jemput Puan Haslina for to deliver your presentation. Thank you very much.
Okay, thank you, Cik Nur Khalida. Assalamualaikum. A very good Friday morning to all of you who are online. Just yourself to be here to join us for this free webinar, which the topic that we have chosen today is very, very interesting for all of you online. I believe you are in the HR and you are very interested to listen to what Datuk Haji Shamsuddin to present in his presentation later on. But of course, some of you may have not heard of us before, or some of you may know what MEF is, but my session today, I will just take around 30 minutes of your time to introduce you to what MEF is. And for those of you who may have heard of us before, probably this is the time for you to refresh what MEF has played the role, and the services and the functions that we do. Okay, so I would like to share my slides with you today, Okay, you hold on, please. Okay, I hope that you can see my slide, Right, what MEF is? Okay, MEF is actually is the point of reference for the views of employers in the country. Employers here meaning any private sector employers, be it the sole proprietor, you are the employer per se, or you are a small time player, an usahawan, or you are the GLC, GLIC dan sebagainya. So for MEF, whatever the case is, if let's say the government or even the media, if they want to know about about the employers' views, MEF will be their point of reference. Okay. We also express business needs of employers. The emphasis on business needs here means that MEF does not only involve in the HR IR aspect of your business, because later on during my presentation from my other slides, I will just pinpoint to you what does business needs of employers in which MEF express your business needs later on, Okay, the slides showed all the press or the media clippings that we appear in featuring the views of the employers, Right. And MEF is also representing the Malaysian employers, be it in the printed media or the electronic media, Right. So in short, those of you online today, if you are in the HR line, or if you are a sole proprietor, you are in the industrial relations in particular, MEF is a place for you to seek professional assistance, how to deal with your problems or the challenges you faced during this era of human resource, and even whenever you have problems or maybe clarification needed in relations to employment laws, Now, so MEF, what is it? It is the central organization of private sector employers, and we get recognition at the national level, di peringkat kebangsaan, at the regional level, which is peringkat serantau, and at the international levels. Okay, we were way back established in 1959, and this year we have been in existence in Malaysia for the last 63 years. And besides the headquarters, which is located in Petaling Jaya, we also operate from 6 other regional branches offices nationwide. Okay, now. Okay, when we claim ourselves to be getting the recognition as representing employers at the national level, as you can see in these two coming slides, these are some of the important examples that MEF represents employers in these councils or agencies or government bodies that have all these councils, where they have the representation of employers, which is MEF, representative of the government, which is the agencies themselves, or perhaps the ministries, and the representative of the employees, which is normally being represented by MTUC or QPEX. So as long as you can see, at least at the NLAC, that is the highest body discussing the labor issues in the country. And then we also have like representative in the NWCC, EPF board, MPC board, SOXO board, dan sebagainya, right? Now, when we claim ourselves to be representing Malaysian employers at the regional areas or regional levels, as you can see, like ACE, which is the ASEAN Confederation of Employers, we are a founder member of the 7 members of ACE, and ACE has been established in 1978. And for CAPE, we have about 20 members. MEF is also a founder member, and it was established in year 2000. Our role there is actually, when all these EOs is a short form for employers organizations, they put themselves in under the umbrella of these organizations, where anything that is in terms of cooperation, cooperation of the employers within the ASEAN, within the Asia Pacific areas are discussed, and we have our representative there. Okay, now, at the international representation, MEF is also an organization which is affiliated to IOE, which was established in 1920, and we have more than 140 countries within IOE, and MEF is one of them, and every MEF will be invited to represent Malaysian employers together. This is all the tripartite in nature, in which we have the government representative, we have the employees representatives, and for MEF, we are representing the voice of Malaysian employers in ILC. Okay, now, this is where I mentioned just now that for the business needs here, in which, as I mentioned much earlier, we are not only dealing with human resource aspects for your companies, for your organizations. Of course, MEF is actually the employment laws, employment regulations in Malaysia. It is within our fingertips, okay? But for the sake of the business needs of employers, we actively participate in the various government dialogues. Misalnya with MITI dialogue, with MOF dialogue, we are also having dialogues with various industry groups. This is to make sure that the employers' interests or business needs are represented, and MEF, we highlight those issues in those platforms. Okay, now. So what do we do? In fact, what is an association without members? Okay, so is MEF. Jadi, MEF is open to any employers, for that matter, yang berdaftar, okay, in which you can enroll to join us as members, and these are the services that we provide to our members. Okay, number one is, of course, this is our core activity, which is industrial relations, IR. And then we also have big data research and information. We also have IT services. OSH is also one of our important services, as well as training. Okay, now, before I proceed further, let me just explain to you clearly. Because for us in the membership department, we are actually the frontliners, yeah? And members or even companies, whenever, say for example, they heard something from the government, announcing such and such regulation or new updates whatsoever, people keep on, and they will ask us, they will call us, and then we will say that, if you're no member, normally you can refer to perhaps labor office, for example. But for PR sake, in which kadang-kala we pass you through. Tapi okay, now, and then later on, companies will ask, how do we become member, and are all your services free, or is it chargeable and whatnot? So before I proceed further, let me just explain to you, yeah. For MEF, for our membership, they are getting free-based services as well as fee-based services. Because for MEF, we are an association-based, okay? So we are a registered association under Registrar of Societies. So we do not get any whatsoever grants from the authorities or from the government. Jadi, whatever activities that we do, okay, some of the services are chargeable, but our charges are very, very minimal. But we do not compromise on the quality. Tapi, of course, if you are our member, you pay a certain fee for retainer fee lah. We call it like a subscription fee. Tapi we provide you free services as well and fee-based services. So what are those? The free-based services, of course, if you're a member, you give us a call, we will advise you, guide you over the phone, email, fax. And we also have, remember, I mentioned to you the IT services. We also have members portal within our website. And you can also make appointment to see our consultant face-to-face at our office premises. Okay, that will be free. We also regularly email blast to you. Okay, the email blasting ni, our emails memang banyak. Okay, say for example, as I mentioned tadi, kalau ada new regulations atau new announcements by the government, be it from the Ministry of Human Resource ke Ministry of Health dan sebagainya, we will advise our members via our email services. Okay, you will be receiving, and every member company, we will allow 4 persons within your organization to have access to our members portal. Okay, now we also provide simple here. I stress the word simple written opinion. Katakanlah if you have already a letter of appointment for your new employee, say for example, yeah, you would like us to review, katakan, so that is considered simple lah, okay? Or anything that maybe you would like to answer to the authority pertaining to employment, kan? Tapi you already drafted, you would like us to give you some views on that. That is, we call it simple written opinion, yeah? And that would be free. Okay, now, monthly meetings. Of course, as a HR practitioner, you will have to update yourself in the current scenario or in the current IR regulations of the country. Jadi kita ada monthly meetings, yeah, in which please make full use of the platform where normally sekarang ni our monthly meetings are being conducted online. Jadi tak kira lah how many people from your IHR team can join our monthly meetings. Biasanya our monthly meetings will be discussing current disputes. And among the agenda, ada kalanya, let's say the first part of the meeting too, there will be a talk, say for example, from the among the membership, they were asking if MEF Secretariat can arrange, maybe, with the new, contohnya HRDC punya regulation ke apa benda, we would like to get the clarification from HRDC, contohnya. So the Secretariat will arrange for an HRDC officer to address our members via our meeting platforms. Ini contoh. The rest will be the current disputes. And then discussion lah. Jadi it is also a platform for networking for you. Okay. Now that is the monthly meetings, which is also part of the free-based service. Okay, now, as I mentioned tadi, 4 persons within your organization will be given user ID password. yeah, so that you can have access, because what you have been approaching or click, maybe it is MEF portal, tapi this one is members portal, jadi you need the special user ID password. Jadi there would be macam contohnya a column where ask MEF. Okay, jadi our IR consultants will address to all the questions posted there. Jadi macam you as an HR practitioner or as an employer, you can scroll down, you browse through. This is like a learning platform for you, yeah. Okay, now jadi another one is of course the WhatsApp group lah. Ever since like last year, many companies practice the work from home platform ke apa bermode. Jadi we created the WhatsApp group within our IR consultants. Each one of them manage a certain WhatsApp group, yeah. Okay, now what will be under the fee-based services? Of course, number one is court representation and consultancy packages ni. Okay, of course. Katakanlah, if your company is having an industrial court or labor court cases lah. Okay, now, jadi there's no need for you to run helter-skelter, cari the good lawyer to represent you. Tak payah. Because MEF will be there, kita ada pool of experts within our IR team. Okay, just for information, our IR team members, they are very qualified and very experienced consultants. We call them consultants. Okay, jadi within our IR team juga kita ada ex-court chairman yang katakan, let's say if we have court cases, katalah the case is so bad lah, you manage it without our assistance before lah kata, and then you turn to your lawyer pun dah mess up the case ke whatever. Jadi contohnya you come to us, you become our member. Only members are eligible for this service. Okay, remember the court representation dengan consultancy packages under fee base ni, only members we will service them. Okay, now jadi within our team tadi, as I mentioned, kita ada a sort of macam expertise. We will give you the weightage. Sama ada you really do it badly ke before this ke apa benda, we will advise you accordingly. Sama ada, I think it's better, you settle it out of court ke, because ada chances menang ke tak menang, we can weigh for you the case. Jadi court representation is chargeable but very, very minimal. Okay, now, we also have consultancy packages. Consultancy packages is something like you like to have macam contohnya IR or HR audit, OSH audit. Okay, we can do it for you. Okay, lepas tu contohnya you have macam handbook, to have a new handbook, or macam contohnya you already have a handbook, you would like us to review, ataupun contohnya you would like us to start from scratch. Okay, itu pun ada juga. Even handbook in English to be translated into bahasa pun boleh. So that all falls under the consultancy packages, where we will study the document, see the complexity of the documents, and then we will give you a quotation. If it is agreeable, then we go ahead lah. Okay, something like that. And just before that, let me also emphasize to you that MEF by law lah, we can together with the employer appear in the IR department conciliation cases. You tak boleh bawa lawyer luar. Okay, jadi MEF consultants can together with employers, kalau you ada conciliation cases at the IR department, we can also represent you. Okay, now the three other bullets tu, seminars, webinars, conferences, trainings and publications, itu 3 fee-based services kan. It is open to members and non-members. Of course, members dapat good discounts as compared to non-members. Okay, right? I hope you can understand, because before I go through to other slides, just to be clear on this. Okay, now. Kenapa tak gerak ni? Somehow it's stuck here. Sekejap. Can siapa tu? My slide is stuck here, cannot move. Okay, anyway, any other, sesiapa ada soalan so far before I move on, because suddenly my slide stuck here. Kejap. I ensure. Okay. Okay, I open up balik. Alright. Okay, now, so I move on to industry relations services. Okay, this is our core activity. MEF selalunya people come and join us because of this service. Okay, I believe that IR services tu memang MEF punya core activity lah. And Datuk Haji Shamsuddin Bardan, our executive director, ramai orang cakap he's the icon of IR in the country. Okay, now, let me just recap apa yang I cakap tadi, which is advisory to give you the professional opinion. We can provide you via phone, fax, email, face to face. Kalau kata better come to our premises. Kalau kata you would like us to go to your premises, it will be chargeable under consultation at members' premises. So better datang to our offices, which are located nationwide lah. Tadi ada mention dekat you. Okay, now, so we have members group interaction, we have court representation, all that, conciliation, monthly meetings, training on IR and HR audit. Okay, now, so I move on to big data research information services. This is also another service which is very important to MEF. As you can see, survey and publications, you can tengok. Okay, let me show you. Okay, this one quite recently, 22 November. Okay, we launched the survey, which, as you can see, the book yang tu, MEF Salary Executive for Non-Executive, MEF Salary Survey for Executives and for Non-Executives. The two publications, every year we come out with those publications. Kali ni dah rasa dah 27 tahun we come out with the survey every year. Okay, now, so whenever we conduct the survey, it is open to our membership. Okay, the members participate in the survey. So we tabulate, we analyze the survey, the data, and we come out with these reports. Okay, so in November every year, we will call the press, we will highlight what are the findings of the survey. And these books are for sale. Jadi members, non-members, very good discount for members. And our books are not available in bookshops, only exclusively available in MEF. Tapi we open up, jual pada members dan juga non-members. Jadi what entails, these books actually kita analyze it in such a manner that kalau kata you would like to check on contohnya the executive positions, benchmark positions of your company based by location, by industry, by years of working experience, all that, you boleh tengok dalam buku tu. Jadi you can see the trend, what is the trend like for such and such position. Lepas tu, these books also, when we launch the books and we announce to the press, kita juga ada sort of like macam prediction for companies, what will be the bonus like, payment for the following year, macam tu. Dan juga what will be the increment like, for the executive dengan non-executives. Okay, jadi the books are very, very useful because the findings are being quoted by even like Bank Negara reports, by Ministry of Finance report, dan juga by MIDA. They come up with the contohnya the extract, what is the salary like for such and such position, for investors to know when they want to come to Malaysia. Contohnya. And then yang buku-buku yang belakang tu like the fringe benefit survey pun kita tak buat every year, maybe 3 tahun sekali, because fringe benefits bukan company nak review every year kan. Okay, jadi these books are very, very useful, and please you surf MEF website to look at these books, what are the highlights, the preface whatsoever, lepas tu harga dia macam mana. Okay, now, yang ni ialah IR series. Tadi tu economic series, this one is IR series. Okay, Probationers and the Law is the latest publication. We launched the book during our IR conference in November. Okay, jadi all cases pertaining to probationers and the law. Okay, let me just emphasize to you that our books bukan sebarang-sebarang textbook. Okay, these are the practical guide to all the HR personnel out there. Because kalau katakan contohnya buku yang hijau tu, Practical Guide to Human Resources Management, this is a compilation of templates. Because even macam semalam pun saya dapat satu question from I believe it is a potential member asking, do you have a sample of surat of secondment to be given to my employee, ataupun maybe on probationer punya case you nak apa extend ke whatsoever. Jadi templates. Being the frontliner, banyak cases saya me and my team face in which orang tanya, ada tak contoh surat? Ada tak, can you share us? Tak boleh. Our members surat-surat menyurat and documents are confidential. Jadi the management decided to come up with this practical guide. Our books are all practical sebab the editors, the authors are actually our IR consultants, where they bring in dia punya experience and expertise. Jadi we come up with all those guides for you. Okay, now I move on. Okay, lagi satu services that we provide is the training. Jadi MEF kita ada our training academy, where we call it MEF Academy. Dulu training was only macam a department within MEF, tapi because kita offer so much, a wider spectrum, bukan saja short certification courses, we also provide diploma courses, degree courses dan sebagainya via our collaboration, ya. Okay, jadi just a quick one. The type of courses that we undertake, be it from the HRM, HRD type of courses, okay, you just bear in mind that our courses, we conduct either in-house ataupun public courses. Okay, now, IR courses memang selalunya sold out. Jadi macam contohnya sebelum ni kita buat through online, tapi off late ni dah boleh kan, since COVID tu dah reda, kita buat face to face. Biasanya our IR courses memang sold out. Okay, because we are being known of being the MEF is the IR expert lah, IR specialist in the country. And then we also have OSH. We also collaborate with industry specialists, because if you look at our MEF Academy punya website, kita pun ada juga macam courses on management, finance and taxation, IT dan sebagainya, because we collaborate with the industry specialists. We also have academic programs and conferences and seminars. Okay, now. So other MEF events memang banyak lah. Okay, baru-baru ni hari tu Datuk Shamsuddin just habis dia punya the series practical implementation of EA with the latest amendments kan. Satu hari bulan Januari ni, the EA punya ni kan, introduction or maybe the implementation lah of the amendments semua tu. Jadi Datuk baru saja habis dia punya series of seminars on this. Lepas tu yang lain-lain jugalah kita pun bergabung, berkolaborasi with tax, LHDN dan sebagainya. Okay, now ini membership, a quick through of what MEF is. Okay, jadi any company out there, if you are a senior berhad ataupun you are an enterprise, as long as you are a registered business entity, you have employees. Okay, syarat kena ada employees. Barulah nama employer bukan? Jadi you can join us under single company or group. Okay, now. Untuk group tu, something which let's say kalau kata you have affiliate ataupun betul-betul subsidiary lah, dengan syarat the HR function is centralized to the holding, to the induk tu, then you can opt to join your subsidiaries under group membership of MEF. Okay, now. So ordinary membership, kita entrance fee sekali saja 500. Okay, that is processing fee. Annual subscription is being determined by the total workforce of your organisation. Kita ada the formula there. For the first 300 dulu, kita ada 100 employees, RM10 per employee. Second 100, RM8 per employee. Third 100, RM6 per employee. After the first 300, which kalau kita total up, 1,800, 2,400. Lepas tu RM1 satu orang. Okay. However, please apa tu, tengok ni, minimum dia 1,000. Kalau kata you ada 20 orang, it's still 1,000. Kalau you ada 95 orang, it's still RM1,000 because that is the minimum. Maximum kita 6,000. Ada company yang ada, kalau contohnya you ada lebih pada 3,900 employees, maximum lah 6,000. You ada 20,000 employees pun 6,000. Okay? Now, jadi kita juga ada association membership. Okay, ini tak payah kalut-kalut. You terfikir sekarang your company ada sama ada you bawa the umbrella of any industry group. Okay, you tengok Okay, now. Jadi sekarang ni, this coming to slides ni, saya just nak tunjuk yang highlighted in yellow tu, actually, they are already our association members. Okay, diorang yang saya asteriskan tu because any one of you di bawah these industries and your company is a member of these highlighted, the yellow highlighted associations, ada something which is good for you, which I will explain kejap lagi. Okay, now tengok kat sini. And then even if you are a member of British Malaysian Chamber of Commerce Berhad pun, you will be eligible for the one that I'm going to present shortly. Okay, ni yang lain-lain lah. Andai kata sekarang ni you are representing an association ataupun your company is a member of any industry group, tolong come approach us. Kita explain to you what this association membership entails, ya. Okay, now, this is something which I would like to highlight to you. Kalau kata you are under those yang highlighted in yellow tadi tu, okay, you are eligible to join MEF with a 20% discount. Kalau contoh you punya employees ada 30 orang, you kena bayar RM1,000. Tapi you di bawah any one of those associations tadi, misalnya kata you di bawah Malaysian German Chamber of Commerce contohnya, jadi you bayar kita 800 saja. You tak payah bayar RM1,000 and all the services that I mentioned tadi, jadi you will be getting. Tak ada sikit pun kekurangan di situ. Cuma kita bagi you discount on the subscription fees. Okay, now. Jadi this is the growth lah. Slowly but steadily. Sekarang ni kita, that was in October. November sekarang kita dah ada lebih kurang dalam tambahan dalam 30-40 companies lagi lah. Okay, now. And then this one is the number of employees employed by our members, both in the ordinary as well as in the association members category. Tahulah, because of late ni banyak company dah shrink kan, dia mengurangkan dia punya workforce. Jadi dulu we used to have about 3.1 million employees covered by our members, tapi sekarang dah lebih kurang dalam 2.9 million lah. Okay, now, yang ni the how our membership di seluruh Malaysia lah, di seluruh negara. We even have members in East Malaysia, Sabah Sarawak, kita ada office kat sana ya. Kita ada office di Ulu Tiram, Johor. Kita ada office HQ kita di PJ cover, we call it Central Region, Selangor, Putrajaya, KL, Negeri Sembilan dan Melaka ya. We also have an office in Perak. Northern region to cover the 3 states up north, and East Coast region to cover the 3 states dekat East Coast ya. Right now. Okay. Yang ini ialah something which kalau kata you engage ataupun you employ foreign workers. Sekejap excuse me, nak minum sekejap. Okay, thank you. Okay, this one kalau kata your foreign workers nak dihantar balik ataupun you nak beli two-way ticket ke, boleh gunakan lah, because this is a value added service lah to our MEF members. Baru je kita perkenalkan, jadi cuma dia terhad kepada 8 destination sajalah Okay, I believe those of you yang employ Bangla ke, Nepalese, Vietnamese dan sebagainya can make use of this service. Okay, ini this is very very interesting. Selama-lama saya di MEF ni di membership kan. Okay, yang ni tahun ni kita buat year end special promotion. Orang kata sort of like macam ada festive punya feeling lah nak memberi. Jadi kita sekarang ni bagi entrance fee waiver jimat 500. Okay, jadi for those of you yang ada keenness kata lepas-lepas dengar Datuk Shamsuddin cakap lagilah bertambah interest kan, you would like to join us jadi jangan ragu-ragu, you only have about 15 days more where you can enjoy the RM500 membership entrance fee waiver. Jadi fikir-fikirkanlah dan secara serius lah. Okay, this one bukan orang kata selalu kita bagi the waiver. It is year-end special promotion for all of you out there. Jadi tadi yang di bawah umbrella of association membership pun lagi best. You dah dapat discount 20%. Jadi instead of kata 800, you kena bayar 1000 kan? You bayar 800, lepas tu entrance fee waiver lagi. Lagi banyak penjimatan, bukan? Okay, now. Jadi, tapi dia limited offer sampai 15 hari lagi lah, sampai 31 Disember. Okay, now. Ini lagi satu. For those of you online out there, either you are already our member ataupun you bukan lagi member, baru-baru ingin, alamak, bagus MEF ni sebenarnya. Tapi alamak, my boss susah lah nak convince dia. Okay, never mind. You contact kita di mef.org.my ataupun that is the phone number. We can assist you. Okay, maybe lah we can assist you how to further convince your boss, your management to decide to enroll membership. Because normally saya akan cakap, you give it a try for the first year. You clean up, you clear all the documents yang you rasa macam you nak bersih-bersihkan, you nak get the professional views ke, you cuba dulu our membership for 1 year. You can see that kita sebenarnya for those yang fall under the minimum category, RM1,000 sahaja setahun. It's about RM83 sebulan, RM4 sehari. Lebih kurang macam itulah. And this NMI is something which we would like to offer to you, those people online now, in which you introduce. Tak payah cerita you nak bawa kawan pergi kat kedai mamak pun tak apa, or maybe just words of mouth, cakap your company ada masalah kan, you contact MEF lah. Contohnya, lepas tu bila contact MEF dah bagi you service, yang ni lah tadi, simple opinion dulu. Okay, I will convince my boss. And then your friend tu, dia join, dia enroll membership. So, we will ask your friend, who is the introducer? Dia letak nama you lah. Okay, we will reward you RM450. For the introducer punya, peranan yang you mainkan tadi. But terms and conditions apply here because kalau company you sendiri yang join, you tak boleh lah dapat RM450 tu. It has to be from another person from outside your company. Okay, not you, the HR manager ke apa benda, you rasa, alamak, I'm the one who convinced my boss, I should be getting the 450. Tak boleh. Ini okay lah, you pandai-pandai lah, adjust macam mana. Okay, anyhow, this NMI, the scheme is valid sampai 31 Disember ni juga. Jadi ada 15 hari. Okay, now, itu sahaja daripada saya. And thank you for your patience and thank you for your passion on IR and HR matters, in which jangan tulis ke tempat lain lagi. You know where MEF, kita ada di sana, kita akan sedia membantu. And kalau ada apa-apa enquiries on membership, that is our the website juga, kita ada social media, that is our email address. And you can call us at any time. So thank you for your patience, and kalau ada apa persoalan, please contact my team. Thank you dan Assalamualaikum.
Thank you, Puan Jasina, for the information given and also presentation on what MEF is and services that we offer to members. Let's see if you have any questions or inquiries on pertaining MEF. You can always contact us at the given emails just now. Yeah. Okay. Now we're moving on to part 2. Without further ado, I will invite the HR and IR Sifu himself, Datuk Haji Shamsuddin Bardan, our MEF Executive Director, for his session on fixed term employment, what employers must know. Dipersilakan, Datuk.
Terima kasih, Khalida. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. First of all, thank you very much for your interest to attend this particular session. And of course, for today's session, I would like to share with the participants on the issues around fixed term contract as employers. what should you know about this fixed term contract when you do employ executive or even non-executive or even the top management based on fixed term contract. But before I go to the main topic of fixed term contract, possibly most of you are fully aware about the oncoming implementation of the amendments to the Employment Act, which I would say is major amendments that had been introduced by the government as far as the Employment Act is concerned. And of course, the cost impact can be tremendous. Yeah? And also, of course, we need to be really very, very careful in dealing with this new Employment Act, which is going to be implemented on 1st January, because the penalty now had been increased from 10,000 ringgit per offense to 50,000 ringgit per offense. Let me just say, what is the meaning of per offense? Per offense means that if you have 100 employees and you fail to implement certain part of the Employment Act for the 100 employees, that is considered as 100 offenses. And for the said offenses, the maximum penalty can be 50,000 per offense. So just possibly it's more important for you then to know the in and out of the new Amendment Act, so that your company will not be under the risk of being prosecuted and being imposed with, I would say, heavy penalty. Yeah. Well, I'm on the subject, perhaps all of you had been paying wages diligently to your employees. But question is that whether you had given salary slips to your employee on monthly basis. And when you talk about salary slip is, whether you're giving it in a form of, say, soft copy. Currently, many employers would want to use soft copy as a mean of communicating to your employees as far as wages slip is concerned. But the thing is that under the employment regulation, the wages slip still has to be done in a hard copy way. And you're supposed, as an employer, you're supposed to keep the hard copy. Of course, the hard copy must be signed by the employee concerned. So that is something that I think many employers had not really comply with the employment regulations 1957. And of course, any offenses against the employment regulation is also can be penalized up to 50,000 ringgit come 1st January 2023. So that I think is just a reminder for all the participants here, so that you have to relook at some of your current practices and see whether what you had done actually comply with the Employment Act or not. And this is more important in the sense that come 1st January 2023, every person that you employ, so long as that person has a contract of service with you, and of course, contract of service can be in writing, can be orally done, thing like that. But of course, if you have more than 1 year, 1 month contract, then that contract has to be in writing. So again, these are also, I think, important issues, because previously you are saying that people who are earning above 2,000 ringgit and they are non-manual worker, they are not dealing with mechanically propelled vehicle, and they are not dealing with supervision of manual workers, then they are outside the scope of Employment Act, and you don't have to worry about them, their employment matters complying with the Employment Act. But come 1st January 2023, everyone in your employment has to be treated as an employee under the Employment Act. Of course, those people earning 4,000 ringgit and above, of course, they are excluded from or earning more than 4,000 ringgit per month, then they are excluded from getting the benefit of rest day work and rest day pay. or public holiday work and public holiday pay, overtime on rest day, overtime on public holiday, and also overtime itself, then they are not entitled to termination benefit because Section 60J doesn't apply to them. So in that way, I would say the onus will be much more as compared to the previous provisions. Yeah, and of course, coming back to wages slip, many of us don't realize that wages slip mean it has to be done in Bahasa. Many of us have the wages slip in English, but even that also in soft copy, which is not complying with the requirements of the regulation. And of course, you can do whatever you're doing currently, keeping it in soft copy, keeping it in non-Bahasa Malaysia, but you must get approval from the DG of Labor. Approval means, of course, you have to apply to the DG of Labor. And of course, those of you who are not able to actually convert back to hard copy kind of thing, then my advice to you is for you to actually apply come 1st January 2023 to get the things done in a different manner as compared to hard copy and Bahasa Malaysia as far as a wages slip is concerned. This just as a reminder, ladies and gentlemen, yeah, and of course, that I would say is a critical thing that you need to do come 1st January 2023. And of course, as MEF, basically, MEF actually is trying to take care on the interests of all employers, of course, irrespective of members or non-members. Yeah, but of course, it would be good if all of you can actually join us as member. And just to share with the participants here, what MEF had done really in as far as the amendments to the Employment Act is concerned, you know that the government had gazetted the implementation date to be effective from 1st September this year. But of course, as MEF, we actually had appealed to the government so that we are given more time to implement the amendments. We need to be preparing ourselves to be ready for the amendments. And I had personally spoken to the previous minister, Datuk Sri M. Saravanan, to say that perhaps the government can consider deferring the implementation from 1st September to a later date. Of course, his response then when I proposed that kind of situation is to say that, yeah, he didn't reject the proposal immediately, but he said, yes, we can consider that, but we need to discuss, the government need to discuss in the cabinet and try to decide later. Remember, the 1st September amendments was really gazetted by the government. Yeah, and of course, the government was kind enough and said that yes, we defer the implementation to 1st January 2023. So there was 4 months deferment of the implementation, and that of course give more time for the employers to actually prepare for the eventual implementation. In fact, even right now there are calls from the employers to say that why not MEF seek for further extension or deferment on the implementation, but I'm not very keen in that sense, because I don't think the government is going to respond well to that kind of proposal. Yeah. So coming back to this issue of fixed term contract participants, yeah, I'm sure many of you had actually. I'm not sure my Remy, can you allow me to control the slides easier that way? Yeah. When you talk about fixed term contract, yeah, of course, this is where the employment of the person concerned is actually fixed by the time frame. Yeah. 1 year, 2 years, 5 years, thing like that. Yeah. So in that sense, we call that kind of contract, employment contract, as what we call it as fixed term contract. Yeah. So of course, another type of contract that is also considered as fixed in terms of the duration, is the fact that if you actually tell your employee that you are actually engaging the person concerned based on specific tasks. If you look at, say, for example, many in the construction industry basically say that I engage you for this particular project to build, say, for example, the elevated highway. So the duration of the contract is for the duration of the project itself, can be 1 year, 1.5 years, or 2 years kind of thing, depending on whether the project is completed or not. And once the contract is completed, then of course the contract come to an end. So of course, when you talk about this kind of contract, it is very common for it to be done when it is a seasonal work. And of course, or some of you may have engaged some employees post-retirement. You want to put them on fixed-term contract, by all means, yeah. And of course, when you talk about people being placed on fixed-term contract, the contract come to an end at the end of the contractual period itself, or of course, if the project is also completed. So here, of course, there are many questions that may be raised, whether there is a need for the company to actually issue a notice of termination when the contract is going to come to an end, or whether the company has to give notice of termination when the contract, when the project is coming to completion. So I'm going to discuss that later, ladies and gentlemen. And of course, when you talk about, this issue about non-renewal of fixed-term contract, whether it can amount to wrongful dismissal. Of course, there are a lot of possibilities, ladies and gentlemen. And of course, yes, if we don't manage our fixed-term contract in a proper way, and this is where there are occasions where the court may say that, yeah, your non-renewal or your ending of the contract really amounts to wrongful dismissal, and that can, of course, be a lot of issues around it. Yeah. Let us just perhaps look at this case, the Hanchang High School case. Yeah? This is a very, I would say, important case as far as matters pertaining to fixed-term contract is concerned. Yeah? And of course, this particular school is a very old school, established in 1953. And from the inception, from the word go, from 1953, the company actually had engaged teachers on fixed-term contract. Normally, of course, it can go up to 2 years, thing like that. And what happened really was, some of the teachers are interested to form a union, associate themselves with the Union of Teachers in Independent Schools. Yeah, so of course, normally, ladies and gentlemen, when the employees started to be friendly with the union, started to form union, many of the employers become very jittery, and Hanchang High School is really no exception. So what actually had happened was, the company was ordered to really recognize the union. Yeah. So once the minister had ordered the company or the school to recognize the union, they also become more jittery. And what they had done was the board of directors decided that the teachers' contract will not be renewed. So of course, there were 35 teachers involved, and all of them were informed that they are not given any new contract on the expiry of the existing contract. And of course, now when this matter, of course, at that time, if you look at Section 20, it is not an individual claim. If you are members of the union can actually represent you and take up the matter on behalf of all the employees. So this is what really happened. So the union filed a case at the industrial court, of course, first at the RR department, and then RR department referred the case to industrial court for adjudication. And of course, at that time, of course, the case was heard by the industrial court. And of course, the issue of whether the fixed term contract, when they actually engaged the teachers, from inception to 1985, based on 2-year fixed term contract, whether really that is a form of what they call it, a genuine fixed term contract. Yeah. And of course, the court is very concerned with the fact that if you're talking about fixed term contract, which is not genuine, then of course the teachers, the people involved in that kind of contract had been deprived of the what they call it as security of employment. Yeah, and of course, in that kind of situation, when the industrial court looked at the employment of teachers by Han Chang High School, it was really something like this employment is actually an ordinary permanent employment. But of course, the court concluded that it was really being dressed up in the form of temporary fixed-term contract. And that's where the problem started. So once the court had come up with that kind of finding, no, Remy, I don't seem to be able to, but you just scroll the PowerPoint, yeah. And of course, in that kind of situation, yeah, of course, the industrial court say that really this is something that had not really been in compliance with even the provision of Section 11 of Employment Act. I'm going to touch again later on Section 11. Yeah, this is where they say that this fixed-term contract of teachers are really not something which is genuine. So what the court says that if it is really a genuine fixed-term contract, no problem. Say for example, what do you mean by a genuine fixed-term contract? Say for example, nowadays we as companies, we would like to digitize our operation, we would upgrade our IT system, thing like that. So in order to do that, you don't want to engage permanent staff. So what you can do to say that, okay, look, yeah, we engage you on this particular project, which is not normally done, but this time around, we want it to be done in that manner. So you engage them to do that particular project. And once the project is over, so the contract is no longer there, the contract comes to an end. So in that kind of situation, the court is prepared to accept that there is a kind of genuine fixed-term contract that we are talking about. Yeah. So of course, if it is really a genuine fixed-term contract, shouldn't be any problem. But of course, in the case of the teachers, next, Remy, the court say that this was really not genuine. And what the court says is that, yeah, it was in fact amounted to wrongful dismissal. And the court actually ordered the teachers to be reinstated. Yeah? Just imagine, you thought that you have a fixed-term contract, went to court, the court said that no, this fixed-term contract is not genuine, and because of that, the court ordered the teachers to be reinstated. And of course, the company, the school, took up the matter to the High Court, and also they lost the case at the High Court. The appeal was dismissed, and the matter was subsequently referred to the Supreme Court. But at the end of the day, still, the decision of the Industrial Court was upheld, and the teachers were really ordered to be reinstated. Of course, when we talk about reinstatement, ladies and gentlemen, of course, it's a very costly affair. And of course, back wages will be payable from the date of dismissal to the date of hearing. And in 1985, the issue of limiting the back wages to 24 months doesn't arise. So it's a full back wages given to the teachers when they were reinstated. Next. And of course, this is another case where actually, the contract, was also supposedly on fixed term contract, and of course, what the company had done was, of course, there are some issues with the two claimants here, and the employees actually were transferred, to other places, and one to Malacca and things like that, and of course. There is also a reduction of commission from 3.5% to 1.5%. And of course, they appeal against his transfer and reduction of their commission, thing like that. Next. And of course, then of course, the employees or the company actually disagree with that. And of course, these two employees went to the industrial court, and of course, the court concluded that this employment really were in fact permanent, ongoing position. And of course, the court did mention that a genuine fixed-term contract should be for a short period, one-off or seasonal. And of course, in this case, the employees' contract were for 15 years and 9 years respectively. And that's why the court here, of course, the court did not order reinstatement. The court ordered compensation in lieu of reinstatement and back wages. Next. And of course, when we talk about genuine fixed term contract, really, it automatically expires when the time is up. And of course, in that kind of situation, there is no legal obligation on the part of the employer to provide any further employment. And of course, in that kind of genuine fixed term contract, your letter of non-renewal of contract is not a letter of termination, but of course, statement of the fact that the contract actually is coming to an end, just to alert the employee concerned that his contract of service on fixed term is coming to an end at certain period. Next. And of course, again, this is, I would say, a good example where the court do recognize fixed term contract as genuine. So in this particular case, what happened was that Mr. Vasagam was actually, Mr. Vasagam is a well-known trade unionist, and he was employed as an executive secretary by the Resort World Pahang. This is Genting Highland Union. The Genting Highland Union is in-house union for 1 year, fixed term contract of 1 year. And of course, the renewal of the contract is at the discretion of the union. And of course, when the union decided that the reason why the company engaged Mr. Vasagam for 1 year was to train up the other prospective successors within the union itself, because, like I say, Mr. Vasagam is a very, really an expert in union matters, and of course, his role was to actually impart his knowledge to the possible successors. So when it was done in that manner, of course, at the end of the fixed term contract, the union did not renew the contract. And of course, when the matter went to the industrial court decided that this contract, fixed term contract, was a genuine contract. And of course, at the end, when the contract expired, there was no dismissal. And of course, this matter was, in fact, being challenged by Mr. Vasagam to the High Court, but the High Court said that it was a genuine contract, and of course, even the appeal to the Court of Appeal was also not successful. Next, Remy. And of course, now this is important for us to just perhaps appreciate what the Court of Appeal said in the Vasagam case. It was a genuine fixed-term contract of employment. In normal circumstances, such a contract automatically comes to an end of itself in the absence of express renewal. In normal parlance, there is neither a resignation nor a termination, and the letter of notice not to renew the contract was not a letter of termination. It was simply a letter of non-renewal. So you can see that here, if it is a genuine fixed-term contract, the industrial court and even the higher courts are willing to say that, yes, this is a genuine fixed-term contract, we respect it, and the employer has every right not to offer further employment upon the expiry of the fixed-term contract. Next, Remy. And of course, it's the same thing with the case of Muhammad Sahini. He was employed as a producer, yeah, and of course on a fixed-term contract. Again, on expiry, it was not renewed, and of course, in this particular case, the court did mention that yes, since it is a fixed term contract, a genuine contract, so there is no need to even issue notice of termination. Of course, normally in a fixed term contract, there is also a clause to talk about notice of termination, and the court recognized that notice of termination of 1 month is only applicable in a situation where the contract is to be terminated by either party before the expiry date. Yeah, so of course, if the company or the employee concerned want to end the contract before the expiry date, then of course the clause on notice of termination or notice of resignation will be applicable. Next. Now, of course, the other part is this issue of legitimate expectation. Yeah, so when actually you are employed by the company on a fixed term contract, when a company actually employ an employee on a fixed term contract, of course, for the first year, there is no expectation for the contract to be renewed. But say, for example, if the contract upon expiry is being renewed, and of course, being renewed for the 3rd year, for example, then the employee may say that I thought that, the contract will be renewed, forever kind of thing, because then that's where the employee may say that actually, as an employee, even though I know that I'm employed on fixed term contract, but I has a legitimate expectation that my contract will be renewed upon expiry. Yeah, so this is where again, we need to really look at our own practices and see how can we move away from that particular situation. Next, Amy. And of course, this issue about this particular case, is the court actually is looking at whether employees on fixed term contract has legitimate expectation that his contract is to be permanent. Yeah, of course, you know that the industrial court, or even for that matter, that the higher courts is always leaning towards the employee concern. And of course, they actually find favor more on permanency of employment rather than temporary fixed-term employment contract. Yeah. So of course, this is where again, the courts say that if we actually everyone goes on fixed-term contract, then where is this issue about security of employment? at the end of the contract, then people lost their job. Yeah? And of course, here, what the court had commented was to say that in such situation, society will crumble. Individuals driven to despair. Families' well-being are jeopardized. Children's schooling interrupted. And debtors encouraged. When a workman does not enjoy security in the form of continuity and permanency of employment. So here, I would say that perhaps, I did mention to the participant about employment of people post-retirement. Normally, for this group of people who are engaged after retirement on fixed-term contract, there shouldn't be any major issue. But of course, the major issue arises in the event the company actually adopted the policy of fixed-term contract for people who are well below retirement age. So that is something that perhaps we also need to consider, and perhaps we can discuss it further later on. Next, Remy. And of course, the issue of engaging people on fixed-term contract, especially as in a senior position, it is quite common, yeah. And of course, in a situation where the really the job is permanent job, it is permanent in nature and it's not one-off thing, then possibly the court may not find favor for that kind of practice by the company, yeah. And of course, we do know, for example, that in many companies, the senior management people are always put on contract, and they are well below the retirement age. And of course, there are also practices, where employees or where employers actually wanting to convert what you call it as permanent contract to fixed term contract. And of course, normally when we do that, of course, we talk to the employee concerned, employee like more or less like have no choice kind of thing. But we company also want to come up with sweeteners to encourage this permanent employee to switch to fixed term contract, especially for the senior positions. And when that happen, their total emoluments will be, of course, being increased possibly by 30% to by 40% kind of thing. But then again, on the expiry of the fixed term contract, after so many renewals, quite a number of these people also goes to court and challenge the company's action. And of course, the court, in cases where they feel that the contract is not a genuine fixed term contract, will have no hesitation to actually say that the termination or the non-renewal of the contract actually amounts to dismissal. Next. Look at this particular case and look at what actually the court actually says in this case. Yeah? And of course, in this case, the case doesn't really go to industrial court, but was challenged at the High Court. Of course, most of the participants here would have known this personality, Dr. Chandra Muzaffar. So he was an associate professor in up north, and of course he was offered as a professor's job in Of course, that job is for 1 month, yeah. And of course, when it expires, of course, the contract or the fixed term contract was not renewed, thing like that, yeah. Of course, the University Malaya thought that this is just a genuine fixed term contract of employment, and this is just a case of a simple non-renewal of a fixed term contract. Next. But of course, the court actually say at the end of it to say that, okay, look, this guy was a permanent employee, even though with associate professor position, and he accepted the offer by Nusim Layer with the expectation that, of course, he will be made more like a longer term employment, not just for 1 year. Yes, he realized that the contract was for 1 year, but imagine if you are the employee, the in this case, Dr. Chandra had sold off his properties, he's uprooted his family from up north where he's more comfortable, came to Kuala Lumpur, to Nusim Malaya, and suddenly he's left out, after 1 year. So in that case, yeah, of course, the court say that in that case, Dr. Chandra has the legitimate expectation of continuing in employment, to be engaged, as a contract professor, yeah. And of course, in this case, things was not done in that manner. Then, of course, at the end of the day, the court did not order reinstatement as far as the High Court is concerned, but awarded him some compensation. Next, Remy. So the compensation given was not pretty high, but it's about 115,000 for this particular case. Next, Remy. So there are also cases where the contract on a fixed term is terminated prematurely. Yeah. So in that kind of situation, what happened then? Yeah. It is very consistently done by the industrial court to say that, yeah, in a situation like that where someone actually is employed on a fixed term contract, actually he enjoyed security of tenure for the duration of the contract. So in the event the contract was prematurely terminated, then the employee is entitled to claim the wages that would have been paid to him for the remaining duration of the contract. So, of course, this is interesting, ladies and gentlemen, because if you look at what is going to happen next year, it is expected that next year is going to be a difficult period, yeah, for everyone, not just in Malaysia, but every employer all over the world is expected to be more like a recession. And you can see that the bigger IT companies, the bigger, international companies now had started to retrench, yeah. So like companies associated with Elon Musk and also Zuckerberg had started to retrench, yeah, and this may happen to us. Yeah? And of course, we have a pretty big number of foreign workers currently, more than 1.3 million. And in the event, say for example, you have to actually send them back because you cannot sustain their employment during the challenging period, then the question is whether you're going to be liable for the unaspired part of the contract. Yeah. Based on, of course, the court decision involving premature termination of employment, then that liability for companies, for employers to pay for the remaining period of the contract is real, meaning that there is such possibility that the employees, the foreign workers, may actually start to file claims for wrongful dismissal, things like that. And of course, the court may order the company to pay for the remaining period of the contract. But of course, we had experienced this during the last financial crisis, where we sent back about 800,000 foreign workers. Or now, of course, we don't call foreign workers as foreign workers. Come next year, 1st January, we have to call them as foreign employee. That is part of the amendments within the Employment Act amendments to be implemented on 1st January. So, of course, at that time, perhaps the awareness about their rights as far as foreign employees are concerned may not be very high. So I had assisted a few companies then to say that possibly we negotiate for a win-win situation. We don't pay the actual sum actually due to the employee for the remaining period of the contract, but we just pay a sum that is acceptable, that is agreeable to both parties. So in that sense, of course, there is no issue about the employees claiming for the full benefits for the remaining period of the contract, thing like that. Yeah. Next. And of course, this is one of the cases that actually, at the end of the day, the court say, pay the remaining period of the contract. Next, Remy. The Kartikesu case, yeah, versus Malaysia Airline. Yeah. Next, Remy. There are a lot of, I would say, practices when the fixed term contract become a bit popular. Yeah. And it is like a trend for employers now to place employees on fixed term contract, yeah, for example, 1 year, to see whether the employee concerned is suitable based on skill, knowledge, and conduct, or attitude and character. And of course, instead of saying that this is a probation period, you call it as fixed term contract. And of course, in the event the employee concerned does not really show the true potential during the fixed term contract, then the employee may just may possibly be the contract will be ended, and the employer will not actually offer further contract to the employee concerned. Yeah. So this is something whether we need to really decide for ourselves as to whether this is something that is really good or really something that may not be good for the company. Because to me, when we talk about probation, it should be managed as a probationer. Of course, fixed term contract employees, of course, yes, we can actually manage the performance also, but may not be as meticulous as it ought to be when you're dealing with a probationer. Next. And of course, this is a case where, this particular person concerned was actually engaged on a fixed term contract. Yeah? And of course, the employment actually came to an end at the end of the period. So the company actually terminated the contract just about 3 days before or 2 days before the expiry date. Yeah, you can see that the contract is up to 8 April. Sorry, the contract is up to 8 April, and the termination was done on 7 May. Yeah, so really it's at the end of the contract itself. So of course, in this case, there was appraisal done, and the appraisal was done at the end of the 9 months performance, and the company's funding was to say that she need to learn more, yeah, of her job scope, thing like that. And of course, as far as the company is concerned, after the 9 months performance appraisal, after the 9th-month performance appraisal, the employee concerned did not show any improvement. And in that case, of course, the contract was not renewed. Next, Harry. And of course, when the contract was not renewed, as the performance was not expected as what is expected by the company, the court say that this is really not a dismissal. So you cannot challenge that as a dismissal. And the court still say that, yes, this contract that you have on for 1 year, even though it's to gauge the performance of the employee concerned, the court say that it was really a genuine fixed term contract. Next. So the question is that when someone is actually, the contract come to an end, yeah, when the contract is not renewed, a fixed term contract, so question is whether this would amount to termination within the meaning of Regulation 3, Employment and Termination and Layoff Benefit Regulation 1980. I mean, as a matter of interest, ladies and gentlemen, with effect from 1st January next year, I said that everyone engaged under a contract of service will be employees under the Employment Act, irrespective of his wages. Yeah, that I think is something that I think we must come to terms. Yeah. So in that sense, question is, how do we then deal with people? And of course, we are very mindful about the effect of Section 61J, yeah, on termination and layoff benefit regulation. And of course, this termination and layoff benefit regulation 1980 was actually made under that particular section by the minister. So, of course, if you look back at the status of employees earning more than 4,000 ringgit come 1st January 2023, even though these people are people covered by the Employment Act, but they cannot claim for termination benefit because that particular clause say that they are excluded from enjoying that particular benefit. But as far as other people are concerned, people who are earning below than or less than 4,000 and less, and people who are manual worker, people who are dealing with mechanically propelled vehicle, and people who are actually supervising manual workers. So this group of people can claim for termination benefit. So assuming that you engage someone under fixed term contract and that contract come to an end. So whether that particular act of not actually giving another contract and making the contract lapse, whether that particular situation amounts to a termination within the meaning of the termination and of benefit regulation. Next, Remy. And of course, in this case, when we look at the law itself, especially when you look at Section 11 of the Employment Act. Section 11 says that a fixed term contract will come to an end upon the expiry of the contract itself. Or if you're engaged on a contract that talks about doing specific job, then that contract will come to an end upon completion of that particular job. So in that kind of situation, of course, we can argue as employers that we are not actually terminating the employee. The contract just come to an end upon expiry. But again, that also depends very much on our own practice as employers. I had seen cases where the employer actually issue a letter of termination, telling the employee concerned that your contract is going to expire 1 month, after this. And of course, the company say, we are hereby giving notice to terminate your contract. Okay? So the question is that when we do like that, does it amount to termination? Ladies and gentlemen, the answer would be yes. And if you look at the famous case of Dr. Dat versus Asunta, yeah, exactly that what had happened. Actually, Dr. Dat's contract was supposed to come to an end, but then the company, Asunta, somehow issued a notice of termination, just as provided for in the contract. They say that, okay, based on what the contract provide, we hereby give you 3 months notice of termination, and the end of that notice period actually coincide with the expiry of the date of the contract itself. So the matter went to industrial court, yeah. And at the end of the day, even up to the federal court, at the end of the day, the court say that terminating a contract by just giving a contractual notice amounts to what they call it as termination simpliciter. You don't have a good reason to terminate the contract, except that it is terminated based on what the contract provide. So in that case, the court say that, since termination is also equal to dismissal, when you terminate the contract without good reason, it amounts to wrongful dismissal. So again, I think here is you need to be very careful. You don't have to terminate the contract. If you do terminate the contract, then actually the company is giving opportunity for the employee concerned to file a claim for termination benefits under the termination and layoff benefit regulation. What should have been done is that even if the company want to say something, the company can issue just a reminder to the employee concerned to say that your contract will come to an end on this particular date. You don't say that your contract is terminated. So you don't say that actually, the company is not giving you any other offer of employment. It's sufficient for the company to say that your contract expires on this particular date. Yeah. Next. And again, of course, in this particular case, when the court actually in the Nadaraju case recognized the fact that when the contract come to an end, it is not really a termination. Yeah, of course, provided the company did not issue, payment notice of termination, thing like that. So in this particular case, what happened was that the contract come to an end, and the contract was not renewed, but the employee concerned filed for termination benefits. Yeah. Of course, the employee concerned also filed for payment in lieu of wages, in lieu of notice. So, of course, at the end of the day, the court say that when a fixed term contract comes to an end, the contract of service is not terminated within the meaning of Regulation 3.1. So here, of course, again, we should be very careful in actually communicating to your employee. You need to use the right word. You need to use the right term to say that the contract comes to an end. And of course, you don't have to say that the contract is terminated. And of course, on another note, ladies and gentlemen, I mean, similarly, in cases of medically boarded out, similarly in cases of frustration of contract. For this kind of cases, we are not saying that we are terminating the contract by giving the contractual notice, but we just say that, based on what the SOCSO panel had decided, so you are hereby medically boarded out. You don't give notice. You just say that you are boarded out with, of course, immediate effect, in the sense that once someone is being declared as medically boarded out by SOCSO panel of doctors, then you cannot legally employ such person. And similarly, in situation where you want to end a contract based on frustration of contract, assuming that your employee got detained for non-bailable offences, and of course it will take 2 to 3 years to resolve that case, then by the second or third month, you issue a letter to say that your contract is hereby frustrated. So you're not giving notice of termination, because if you do issue notice of termination, then of course the employee can actually bring back the case under the termination and benefit regulation, and possibly will claim for termination benefits. Next. And of course, in this particular case, of course, the matter went up to even the High Court and Court of Appeal, and the High Court and Court of Appeal actually had, again rejected the appeal by the employee concerned. Next. I had, of course, done this in passing, yeah. But of course, having said so, I must also share with the participants here, there was a court case where this particular expatriate was employed on fixed term contract on various positions. Yeah, and at the end of the day, the contract was not renewed. Yeah, and of course, the matter went to industrial court, and the industrial court say that even if this guy is an expatriate, the employee concern was in fact ordered to be reinstated. Of course, this is, I would say, one of those cases that are very unfortunate for employers. That's why, again, I think it's important for us to really deal with cases of fixed term contract in a better way. Yeah, next. And of course, in this case, of course, what happened was that this particular employee, an expat, was on fixed term contract, but somehow the company actually, instead of putting him in the original position of a regional organizational customer unit manager, the company actually had regraded the employee concerned as business development manager. Of course, the employee went and of course, the claim for constructive dismissal. And this is again, from being a fixed term contract, the case went on as constructive dismissal. Of course, the court say that the change was unilaterally done by the company. And of course, that amounted to what they call it of a breach of contract on the part of the company. And the case was actually sent back for hearing at the industrial court. Yeah. Next. And of course, at the end of the day, yeah, of course, the employee concerned was actually given the payment of the remaining duration of the contract itself. Of course, the court in this particular case didn't do any reinstatement because the court do realize that the employment of expatriate is depending on the issuance of the employment pass, which the industrial court has no jurisdiction to order the immigration department to issue the employment pass. Next. And of course, this is another case where the court really look at this particular case, where the renewal actually was basically not done by the company because, as a musical director for the Malaysian Philharmonic Orchestra, the court say that this is really a short-term contract rather than a long-term contract. Next. Next, yeah. And again, of course, this is involving a restructuring of the banking sector, Filio-Allied Bank with that of Maybank. And at the end of the day, the Filio-Allied Bank don't have any banking license anymore. So in this particular case, of course, once the company had ended the contract because after the vesting order, then of course, there is no more banking position in the company, and the court accepted that this is a genuine ending of the contract between the bank and also with that, of course, the employee. Next, Remy. Next. Then come this particular issue, ladies and gentlemen, yeah. Minimum Retirement Age Act. Yeah. The law, the schedule to the Minimum Retirement Age Act says that, a person who is employed on a fixed term contract of service, inclusive of any extension of not more than 24 months, actually, the Act doesn't apply. The Minimum Retirement Age Act doesn't apply to the employee concerned. What does it mean, really? Yeah. So when someone is engaged on fixed term contract, and that fixed term contract duration is not more than 24 months, including extension. So the law say the Minimum Retirement Age Act doesn't apply. But if you're looking at the matter from the reverse side, assuming that this particular employee who is 40 years, engaged on a fixed term contract, the first year, of course, the company offered him another contract. After the second year, the company offered him another contract. And of course, in the third year, the company offered another contract. So the contract now is 36 months. So at the end of the 36 months, the companies say, sorry, we're not giving you any other further contract. So looking at this particular matter from the reverse side, can the employees say, okay, look, yeah, it's all right. You don't want to renew my contract, it's okay. But now the Minimum Retirement Age Act apply to me. And what is the Minimum Retirement Age Act? Says retirement on attaining the age of 60. And this employee, say for example, is still 40 years. So the employees say, okay, look, yeah, you don't want to renew me, it's okay, no problem. But pay me the remaining period of my service from the 40th year to the 60th year. And is the company prepared to do that? And it's going to be very expensive. That's why you see, I mean, if you actually engage someone who is below retirement age and you go beyond 24 months, I think really it is more like a time bomb. And I would advise you to possibly relook at that practice, relook at that position as to whether you would still continue to call the employment under fixed term contract. Yeah. Next. And of course, there was this particular amendment that was included within the Minimum Retirement Age Act, where for people who are earning 20,000 ringgit and above per month, so instead of the period of 24 months, you're talking about not more than 60 months. Yeah. Of course, the contract can be for 60 months, but provided that wages is 20,000 and more. Yeah, so again, I think we need to be very, very careful. And in terms of trying to make sure that we are not caught by the situation, then we have to really do the right thing when you actually engage these people under fixed terms contract, even after retirement. Yeah. Of course, when you retire people, of course, you need to retire them properly. Yeah. And of course, a lot of issues, a lot of arguments pertaining to retirement. When you say that the employee concerned is retired upon attaining the age of 60 years. That's what the Minimum Retirement Age Act provides. Upon attaining the age of 60 years. So the question that you need to ask is, when will your employee actually attain the age of 60 years? Is it one day before the birth date, on the birth date itself, or is it one day after the birth date? Yeah. Then, of course, if you look at the law carefully, then you should retire your employee when he reaches 60 years, when he attains the age of 60 years. That is on the date he celebrates his 60th birthday. If you retire the employee concerned one day earlier or one day later, then someone can argue that the retirement is not in accordance with the termination and layoff benefit regulation exemption, because the exemption under Regulation 4, under the termination and layoff benefit regulation, wherein you as an employer will not be liable for termination benefits, says that the employee must be retired based on the contractual retirement age. Yeah. And that provision of the retirement age must be provided for in writing in the contract itself. Yeah. So again, I would say that has to be done properly. And when you retire your employee like that, of course, the question is that for someone within the scope of Employment Act, if you want to actually, of course, when I say within the scope, is those people who are 4,000 and below, and of course doing manual work and dealing with mechanically propelled vehicle, or people who are actually involved in supervising manual workers. So for this group of people, yeah, then you have to make sure that the contract between post or pre-retirement and that of employment post-retirement, there must be a gap of at least 31 days. Why I say 31 days? Because the law say if you have two contracts like that and the gap in between the two contracts is not exceeding 30 days. So when we say not exceeding 30 days mean, of course, to break the two contract, your gap must be 31 days. So if you have a gap of less than 30 days, then it is not breaking the two contracts. So they are deemed to be continuous. So assuming if someone is retired on 31st December this year, 2022, then the earliest that you can actually engage him is effectively 1st February 2023. Yeah. So if you actually engage him earlier than that, then of course the two contracts will be deemed to be continuous. As far as people who are earning more than 4,000 ringgit and they are not within the manual work, they are not within the mechanically propelled vehicle work, and also not supervising manual workers, of course, for these people, the gap can be a minimum of 1 day to 2 days, 3 days, depending on your requirement, of course. Next. So, ladies and gentlemen, I had actually tried my level best to actually share with you the issues pertaining to fixed term contract. And what I wish all the participants to do is that you relook at your own practices as far as fixed term contract of employment is concerned, so that no one of your people who are engaged under fixed term contract will later on go to industrial court and the court say that your action is actually amounting to wrongful dismissal, or the employee actually file a case for termination benefits at the Labour Department, and Labour Department ordered against you the payment of termination benefits, things like that. So I would say that proper management of your fixed term contract employees can be very crucial. So thank you very much.
Thank you very much, Datuk, for the presentation and enlightenment from you on the fixed term contract issue. Okay, we'll move straight away to the Q&A. Okay, Datuk?
Sure, go ahead.
Okay, we do have some question here in the pigeon, posted in the pigeonhole, right? Okay, the first one is pertaining to the wages slip or ataupun pay slip. Do we actually need to provide it in hard copy?
Currently, based on the Employment Regulation 1957, it talks about providing the wages slip in hard copy, yeah, and somehow in Bahasa Malaysia. But of course, if you are not able to actually provide the wages slip, of course, somehow it requires the employee concerned to sign the wages slip, and you are expected to keep that wages slip for at least 6 years. But in the event it's not possible for you to do so, you want to move up with time, because now most of the documents are kept in soft copy. My advice to you is to quickly write to the DG of Labour, ask for exemption on that requirement, and you say that you would like to still maintain the possibly the document in English, and also you're allowed to communicate to the employee concerned on the wages slip in what they call it as a soft copy. Yeah. So that you should be getting the approval of DG of Labour in order to do so. Now, remember, I say that if you don't do that, then possibly the Labour Department may actually come to your place, inspect audit your practices, and for each offense, the liability can be up to 50,000 ringgit. Yeah.
You must remember to keep a copy. If not, it will be fine. Okay. Okay. Next question, Datuk. On Ami Mastura case, the contract seems to be a method of evaluation or probation. When the court decided that there was no dismissal, does the correct contract considered as genuine?
Yeah, of course, you can see that in the Ami Mastura case, the contract is just for the first 1 year. Yeah, there was no extension, there is no renewal. Yeah, so again, I think it is very, very important for us to say that, that is in order for us to say that it is a genuine fixed term contract, it has to be for short term like that, most 1 year. Beyond that, then the court will doubt very much whether that contract really is a genuine fixed term contract. Yeah. But of course, if you're talking about foreign workers, is quite different status. But generally speaking, you're talking about local employees being placed on repetitive fixed term contract. Again, that can be very, I would say, risky for the company to do so. And of course, when employers do actually have the intention to actually give another fixed term contract, my advice to the participants here is to say that you shouldn't just say that the contract is renewed. What I would advise participants to do is to say that before the expiry of the first fixed term contract, if the employee is interested to actually serve the company beyond that, then what you need to do is to say that you must make the employee concerned right in to apply for a new fixed term contract. So that the term use is a new fixed term contract. So of course, here when someone apply, it is still the company's discretion whether to approve or to reject that request. Yeah. So, and in the event you actually approve the request, then you say that, okay, look, of course, I had talked about the gap just now. So the gap for someone who is within that parameter of the Employment Act has to be at least 31 days. But those people who are beyond 4,000 and not doing the kind of the three things I had mentioned to you will be 1 day or 2 days is sufficient. So when you actually offer a new contract, it's an offer of new contract. And of course, it'll be very good practice if the companies say that, what are the terms and condition of employment for the new contract? I think our thought is basically, normally we take the easy way things out. Your terms and conditions shall remain the same. That I think is really not advisable. That can work against the company. Yeah.
Thank you, Datuk, on the explanation. Moving on to the question on the posted on the chat box here from Mr. Tony Lee. With regard to the retiring worker, does the employer need to pay his salary until his last working day, which is his or her birthday?
Yes, of course. He is retired on the date he attains the age of retirement, that is 60 years. Of course, that is the end of his contractual period. The contract actually comes to actually, he retires on that particular date. And of course, yes, wages has to be paid when based on the date that he's retired.
Okay, noted, Datuk. One more question from the chat box here from Puan Aslifa. Pertaining to MRA, is it compulsory to state the retirement age of 60 in the employment contract for permanent and fixed term contract?
Of course, if you talk about retirement age for fixed term contract, then actually it is a contradiction in term, because you say that this guy is on fixed term contract and you provide a retirement age. So in that kind of situation, there will be legitimate expectation for him to be maintained as an employee until the retirement age, and I wouldn't advise you to do that. So don't put a retirement age for someone who is under fixed term contract, because that can be damaging to the company, and of course that can show that the intention of the company is to engage him for long term. That's why you talk about retirement age. And as far as the inclusion of the retirement age within the terms and conditions of employment or in the letter of appointment, I would say that it is important. Of course, you say that, okay, look, even if I don't put that, your minimum retirement age act will apply. That is on attaining the age of 60. But remember, we are talking about trying to avoid any payment of termination benefits when the employee concerned is retired. And the exemption under that Regulation 4, Termination and of Benefit Regulation, says that if the employee concerned is retired based on the contractual retirement age that is stated in writing in the contract. So what you need to do is that you must have a retirement age stated in the contract. You must state it very clearly, very specifically. Otherwise, if you're just relying on the Minimum Retirement Age Act, then the employee would have a valid claim for termination benefit, because then he is retired not in accordance with the contractual term as specified in the terms and conditions of employment.
Okay, noted. Okay, this one more question on the chat box. I find this interesting. Do the fixed term contract employee need to have a probation period on their contract? Perlu ataupun tidak?
Yeah, of course, it's interesting because fixed term contract is meant for that duration, say, for example, for 1 year. But the question is that whether the company has a right to say that, anyway, you are put on probation, and when you confirm the person concerned, does it mean that he's confirmed on permanent basis? Yeah. Firstly, of course, yes, as an employer, you have the right to actually put a probation period, even for someone under fixed term contract. Yeah. And of course, you are testing him within the probation period, whether he can actually be given up to even to 1 year. But of course, if he doesn't make it within the 6 months or 3 months, then you say, sorry, we are not going to confirm you. But of course, you need to really monitor the performance of the employee concerned. And the fact that there is a probation period within the fixed term contract employment does not mean that the risk or the contract become permanent contract. Yeah. In fact, this particular matter was decided by one of the industrial court cases in Penang. Yeah.
On the one more question on the you were saying about permanent staff just now. If the fixed term contract continues renew will more than 24 months, shall the employee consider himself or herself as permanent staff? Continue.
Based on the exemption granted under the Minimum Retirement Age Act, Para H, I'm not talking about people who are earning 20,000 and above. So the 20,000 and above is talking about 60 months, not 24 months. So in that kind of situation, there is this legitimate expectation of the employee concerned that his contract is more like a permanent contract rather than a legitimate fixed term contract or a genuine fixed term contract. But really, if you say that the project takes 2 years to be completed, or the project takes, say, for example, 30 months to be completed, then of course you have to explain in that manner. So in that manner, it's better for you to really, make sure that for someone who is within the first tier of coverage for the Employment Act, meaning that wages is below 4,000 and he's doing something like manual work, doing mechanically propelled vehicle work, and also doing supervision of manual workers, then I would say that it's better for you to have a gap of 31 days in between the contract, so that the employee cannot claim that the contract is for continuous duration.
Okay, must have a break. Some break lah between the to renew the contract, right, Datuk?
Yes,
Okay.
yes, sure. But the break
What?
must be 31 days at least
31.
for people who are within the first year of coverage of Employment Act.
Yeah. 31 days. Please take note, participants. Okay, one more. This one is on expat. For expat fixed employment contract, are there any limitation duration atau year? Example, contract is for 1 year and extended every year. Until how many years company can extend his contract?
That's why I think, ladies and gentlemen, we are so used to calling the renewal of the fixed term contract as extension. If I were you, I will stop using the word extension. It is always based on offer of employment, offer of new fixed term contract, and of course, with a break in between. So even as expat, I would say that again the issue of MRA just now, talking about 24 months, or talking about 60 months, those period actually apply before the minimum retirement age act say your retirement is 60. So I would say by law there is no limitation, but necessary implication from the para age of the minimum retirement age act says that if you have, say for example, not the first year of expat, you're talking about third year or third level or second level kind of thing, where wages can be less than 4,000 kind of thing, then of course it's important for you to say that the contract is not more than 24 months at any time. Yeah. And then, of course, if you need to go beyond that, then you must have a break that is considered as a break within the termination and layoff benefit regulation. And of course, for those people who are, of course, earning the higher category salary, 20,000, you're talking about 60 months contract. Yeah.
Okay. Just now you were saying about 31 days of break, right? Tapi ni ada satu soalan. If a worker is under a 6-month contract and the contract is time without a break of 31 days for each contract, is the worker entitled termination benefit when the fourth contract end ataupun tidak?
So, I mean, if the two contract actually is one contract is less than 12 months, but if the contract is now for, say, 6 months, and in between the two 6-month contract, the break is not more than 31 days, of course, he served the company 12 months. Yeah? But here again, whether these people who are under fixed term contract will be entitled to termination benefits will depend on whether the company terminated the contract. Yes, that's why I say never use termination, the word termination, when you don't offer a new contract to the employee concerned. You just say that, sorry, your contract come to an end. So if you look at what the law says under the termination and layoff benefit regulation, for an employee to claim termination benefit, he must prove that the contract is terminated by the employer. So, of course, here the company can say that you never terminate the contract just come to an end. So it's not an act of termination. So if the company is able to prove that the contract is not terminated, or the employee failed to prove that his contract was terminated by the company, then the issue of termination benefit doesn't arise. That's why I say it's important for you to manage the fixed term contract properly. You use the right word, you use the right terminology, because otherwise, if you use the wrong word, you use the wrong terminology, then people will say that they will try to claim for termination benefits.
Okay, noted, Datuk. Thank you for the explanation. Okay, one more question from the chat box from Cik Irfan. Salam Datuk, I have a question. Is an employer terminate a contract due to business turn down, employee not well performed, and etc.? Can we provide the termination letter to the employee? We have a clause in the contract saying that the termination can be done from whichever parties, example, 2 weeks of notice.
Yeah. Let us be very clear that you cannot just terminate the contract by giving the contractual notice. Even though if you look at Section 12 Employment Act, it says that either party can not terminate the contract, and either party means either the employer or the employee. Based on the case I had cited earlier, case of the Dr. Dat versus Asunta, then of course you cannot just issue a contractual notice to terminate the contract. And again here, I would say that we need to be very careful when we do exercises like retrenchment, for example. Of course, retrenchment you can do based on certain principles being complied with, yeah. And of course, normally companies take the easy way out to say that, okay, look, you're not a good performer, that's why you're retrenched. But again, the court may also ask the company, prove that this guy is not performing. And if you're not able to actually prove that the guy is not performing, then of course the court can say your retrenchment is not done validly. And again, of course, I'm not saying that when you do retrenchment, you must follow the principle of last in, first out, thing like that. You can always depart from that principle, but you must have a valid reason to depart from that principle. Say example, that is this particular case of Malaysia Shipyard Engineering, where the actually company departed from the last in, first out principle when they retrenched the employees. They actually had certain criteria to select people not based on last in, first out, but based on certain criteria. So what the company had done was to take the issues of age as a factor. Then they take the issue of performance in the last 3 years, your MC for the last 3 years, and also for your discipline. So all employees actually were appraised based on these 4 criteria. And of course, for each criteria, they have what they call it as demerit points. And people who score higher demerit points were actually, at the end of the day, selected for retrenchment. So the matter went to industrial court. Industrial court say that the company was wrong in doing so. But then when the matter went to the High Court and the higher court say the company had valid reasons to depart from the last in, first out principle. Yeah. So again, I think here, if we have a matter, let us just handle the matter. If the employee concerned is really not performing like what you say, then of course you can take the performance issue as a reason to end the contract or end the employment. Yeah, and of course, you are managing probationers, thing like that. There is such thing as performance improvement plan, thing like the PIP programs that I think you need to do, and also a proper appraisal to be done before the employee concerned is terminated. Yeah.
Okay, Datuk. We actually already passed our ending time. So we are concerned you nak sembahyang Jumaat kan. Can we take another 2 questions from the chat box and then we ni?
Sure.
See you.
We'll do that. Yeah. We take
Okay.
another 2. Yeah.
Okay. This one is from Mr. Chan, I believe. Hi Datuk, expired on fixed term contract. Company released him earlier before expiry of contract, but state a condition that the expired cannot work in Malaysia within 1 year of release. Is this enforceable in Malaysia?
Yes, of course, if the company can prove that, those were the company, what you call it, company secrets, company trade matters that you need to be protected, then of course it can be done in that manner. But of course, generally speaking, the contract that actually prohibit an employee from seeking a vocation, meaning that he cannot actually perform the work in order to actually earn a living. The court is not very keen to accept that kind of contract, meaning that the court don't want to enforce that particular contract because you are actually trying to stop someone from earning a living. And of course, there were a number of cases where the court where they have that kind of situation say that that contract per se under the employment act is under the contract act is invalid and cannot be enforced, yeah? And of course this particular case that is quite popular, always been cited, is a case of a legal assistant that worked with a legal firm, and he has such a contract to say that in the event you leave the company, you cannot work, within certain radius from Kota Baru, and for certain period. And the matter went to court, and the court say that that contract is null and void. Yeah. Unless, of course, is a situation is different. Say, for example, this A actually sold the company's business to B, and B say, okay, look, yeah, since you sell your business to me, then you cannot actually enter into any other business similar to this particular business within 1 or 2 years in Malaysia, for example. That's where the when we talk about the that kind of situation, the court is prepared to accept those things, yeah, but not just trying to prohibit employment.
Okay, noted. Thank you, Datuk. One last question from Puan Azlifa. This one just now is on termination during the contract period, kan? This one is, can an employee in a fixed term contract be promoted during his contract period?
Possible, but if I were you, I would be slow in doing that, because then what difference will be this particular person that is being promoted with the rest of the employees in the company? Yeah. The problem arises in the event you promote him, later on you say, sorry, we are not going to offer you another contract. So your action and reaction is considered as something which is not consistent in trying to put him on a fixed term contract. Just to say, I mean, I'm digressing a bit here. Someone who is on probation, yeah, in this particular case, Pari Parumal case, where this someone working in the legal firm, he was not confirmed, but then he was given his bonuses, he was given his annual increment, he was allowed to take annual leave, things like that. So the court say, by the mere action of the company in treating him just like a confirmed employee, so the court say that he's deemed to be confirmed. So in this case, just like what you try to say that, okay, can we promote him? If you promote him, then of course the employee have a better say that actually his employment is permanent rather than on fixed term contract.
Thank you. Thank you, Datuk. Thank you very much for the explanations and also your vast experience.
Yeah, thank you very much. And I really enjoyed this session. And hopefully, those of the participants that are not yet members of MEF, you can always consider joining us in MEF. So thank you very much. And you have Happy New Year coming, and those people celebrating Christmas, Merry Christmas. Thank you very much.
Thank you. I was just about to say just now on the joining of MEF as a member, sebab this on the promotion, right? Puan Jaslina show us just now, it is some serious time for you to consider lah, with the waiver of entrance fee of 500 ringgit. Thank you very much for our participant. Do contact us at MEF membership at mef.org.my if you have any inquiry pertaining to MEF membership. And also do follow our social media platform in LinkedIn, IG, Facebook, and also TikTok. Thank you very much all. Have a nice day.